It's very unfair, Judge Robinson. It's very, very unfair. It's very unfortunate. We are facing displacement. We're facing retaliation. We're facing discrimination. And this is even more adding to our unfairness. We have to, this is very unfair. This is very, very unfair. It's very unfair. It's unjust.
All right. I understand your objections. Again, you have an absolute right to appeal any decision that I make. And I would further point out for the court rules that the court rules apply equally to plaintiffs and to per se defendants.
But they have not.
So, excuse me, don't interrupt me again. I would further point out that at least on one occasion, you told me that you were an attorney licensed to practice law in the state of California.
In DC, I was once licensed in California, but my first introduction to the state of Michigan is facing an eviction. So I just got here. Now I'm having to.
All right, thank you.
All right, it's very unjust. So I'm studying.
I understand your object. And again, you have an absolute right to appeal any decision that I make.
Absolutely, so we have absolute right also
to interrupt me again.
Unjust
right. I'm going to mute you now because I'm tired of being interrupted.
Court calls the case, People versus Kamu.
Nimish Ganatra for the people.
Good morning, Your Honor. Assistant Public Defender Calvin Hawthorne, appearing with and on behalf of Kamu. Please state your name.
Okay, what are we doing?
Your Honor, we have been in discussions with the people to reach a global resolution. However, we are still awaiting new charges to be authorized. So we are requesting a 2-week adjournment.
2 weeks? 2 or 3? His other case, the other case before me that I think is all part of this, I can't recall what date I gave from my other docket, but
it was the 2nd, Your Honor.
The 7th? That's what I thought. 2nd?
Yes.
Okay, I could set it for the 3rd if you think you'll wrap it up, or I could set this for the 10th. Either way, what do you want me to do?
Let's go with the 10th, Mr. Ganatra. Is that
all right?
What? Your Honor, I do have
one
request.
Hang on 1 second.
One's on the 2nd, one's on final settlement on the 11th.
Okay. He also has, if you're looking for a global resolution, he's got one before me on the 2nd. He also has another that's set for final settlement conference before me on the 11th. So, all right. And we'll try to figure out a date. Yes, Mr. Ganatra, you were saying something, sir.
Your Honor, I wanted to bring to the court's attention, you're aware of the child abuse case and the domestic violence case, because both of those matters are being prosecuted by my colleague, Caitlin Kirby, in your court.
Yes.
Ms. Kirby informed me yesterday afternoon that the defendant is still having phone calls with the victim on the DV case, telling her not to come to court and appear. At this point, I'm asking for this court to revoke his phone call privileges in the jail on all the cases.
Any response, Mr. Hawthorne?
Your Honor, I would ask that you admonish Mr. to refrain from making any calls to the victim and allow him to make calls to our office for legal purposes.
All right. Here's what I'm going to do. With regard to the probable cause conference, I'm going to set this one right in between that. I'm going to adjourn this out to August 10th, 2023 at 9 a.m. With reference, so his bond on this will continue. With reference to his phone privileges, you got it. I'll certainly have a hearing on it if, Mr. Hawthorne, you think it's required, but in the interim, because of the nature of the other 2 cases that I'm familiar with, I am going to revoke the defendant's phone privileges. If you wish to request a hearing on that, you may, but at this point, his phone privileges are hereby revoked. Right. Thank you.
Listen.
They warned me about you. They warned me. I don't even block people, but I blocked you. And I still take your calls. Every chance you get, you want, just like that little nasty text message you sent. That wasn't even my resident, but when they contacted me, guess what? I took care. I hadn't even talked to that woman. And then you want to get up and talk about text messages. And then you want to talk about getting here and doing the work. You are messy, messy, messy.
And if there's a tether on the other one, I'm going to ask that there be no tether on this one.
That's not gonna happen. Miss Ritter?
Okay.
Judge.
That's like asking every police officer to bring their own gun and handcuffs and all kinds of shit, bring their own squad cars. You have to bring your own car and use that as your squad car.
Oh,
No, that shit's all supposed to come with the job.
I'm
Just so
not.
you-
They can't take me to jail for that one, because that's the truth, baby. I'm held under oath.
All right, stop.
All right, Dad, okay.
Okay, hold on. Please do not refer to me as baby.
No, that was my dad. I was calling my dad baby.
So how we, I mean, you just said not all of his fault, or possibly his fault. How is it any of his fault?
I mean, it's not his fault. I mean, we were both at bad places at, at even worse time. And I mean, I know he was just changing his tire, but at the same time, when I approached him, if I recall correctly, I told him like, hey, I wanted to try to get out of there, period. And when I asked him for a ride, it just, I don't know, it wasn't, I guess because my demeanor, I had my shirt off, I have tattoos, maybe I was.
And I see in the pre-sentence investigation that on 2 occasions you did not submit to a drug test. You came to 36th District Court, and for whatever reason, you were not able to successfully submit to a drug test. They told you to go to Affordable Testing Center, and you did not go. Let me be clear. Let me be clear. The things that I'm going to say to you today as to what you need to do on probation, these are not optional. I'm not asking you, do you want to do them? You either want to do them or you want to go to jail. That's how that works. You either want to do them or you want to go to jail.
But we are open for business to the police, the chief of police, to the mayor's office. We are open for business on the city council. When y'all come up here and y'all want to do business with us, 5 or 6 of us, or however my colleagues decide they want to do, we are willing to work with you. Those businesses that's trying to do some investment in the city of Flint, we want to work with
Request for information.
I'll heard Ms. Burns first.
Thank you. Are you stating that to the speaker, are you stating I'm not here to do business? Please clarify. Request for information.
Okay, Ms. Carter.
Are you saying that there's only 5 to 6 council members up here that come and sit here to do the business?
All right, proceed, Mr.
Thank
Murphy.
you. What I'm saying is, if the shoe fit, wear it. Okay. Back to you.
Well, I thought I was on the Zoom thing, but I did everything that the paper told me to do, and I haven't heard anything from anybody.
First of all, you just came in the breakout room, in the waiting room. Let me say that. It's 10:37. You were supposed to be here at 8:30. You just got there because I saw you when your device popped in. So I'm going to send you to a breakout room. Right. I'm going to send you to a breakout room, and someone will try to assist you on getting on video. You're 2 hours late for court. And if your video isn't working, then that means you should have come down to the court. But I'll send you to a breakout room and see if they can get you on video. Just wait for a lawyer to come in and speak with you.
Okay, but another thing, this is all new to me. I don't know nothing. I don't have no.
Listen. Can you stop talking? Okay, there we go. Somebody go in the breakout room with him. All right.
If you are, as you say, an attorney licensed to practice anywhere, at minimum, you ought to have some understanding of courtroom decorum. So we will talk to you all again.
And I understand justice too.
Please do not interrupt me again.
You are using two
I'm
different.
gonna
words.
mute you, ma'am. Thank you.
Mhm.
We are on the,
I'm not a ma'am.
June 27th at 11 o'clock. Thank you all for coming in. We're off the record.
We're looking at a global, perhaps specialty court resolution in this matter. I'd ask you to adjourn this 2 weeks so that we can continue working on that.
Are you the
All
same?
right, thank you, sir.
Yesterday? Excuse
I
me,
didn't
Guy,
hear.
are you the same attorney that came to see me yesterday? You look totally different.
Nope, that's me.
Couldn't be. No, absolutely not. You're not the same attorney that saw me yesterday. Well,
Yes.
maybe I could be incorrect. You don't look the same.
It was me.
Okay.
Um,
Do you remember what we talked about?
yes.
Well, this is nice.
Yeah.
I'm going to, well, I'm supposed to be going to,
Your Honor,
okay.
All right. Did you want the 25th or?
Does the judge know that I've been locked up here for 7 months in max? And I've been on suicide over 20 times and my life is in danger here at this facility? That I had my grandmother died as well as my great aunt, and I'm like really going through
8.
breathing periods. A couple free days.
Judge Simpson's aware is I think familiar with the process of this case.
I am, and I'm also aware that there are 9 charges pending. Just so that we get all that on the record.
I couldn't hear you, excuse me.
So I'm aware of everything that you just said, but also would just add that there are 9 charges that are currently pending.
Okay,
So they're trying to work through to get them all together. I don't want to talk, Mr. I don't want to talk about the charges because anything you say could be used against you. So I'm not going to have that conversation with you.
Okay, because they told me.
Your counsel has indicated that he is trying to do a global resolution for you, which at least on the face of it, from what I'm looking at, makes sense.
So I'm going to.
So, okay, and again, Mr., I'm not arguing with you.
No, because the gentleman yesterday said I was going to mental health court.
No.
Well, the gentleman yesterday is the same person that's here. I don't know what happened.
So I'm not going to mental health.
I've known Mr. Gaddy a long time and he doesn't change forms. Mr. Gaddy, how much time?
Mr. Please stop it now.
No, he was a lot better than you. He was not bigger than you. He was older than you. He had a mask. He definitely wasn't you when he told me I was going to mental health.
Okay, I don't want to go into what we discussed yesterday. Judge, March the 25th will be fine.
It works for the
I
people.
would like to see the same attorney that I saw yesterday that mentioned mental health court.
Okay, one more word, I'm cutting your mic. May 25th, 2023, 9 a.m. Bond will continue in these matters.
And what is
Thank
the
you.
bond, Your Honor?
Thank you.
What
One
is
more
the bond, Your Honor?
word. Cut his mic.
I can check in people much faster, even without the use of JIS. I'm not.
Oh, Lester. Attorney Coleman, do you have something ready?
Your Honor, I don't know I've been waiting for a while. No one has communicated with me on either of my 2 files for the past 2.5 hours. So I'm just trying to see where I'm at in this process.
We've got Ms. Talley who's there. Ms. Talley?
Yes, I'm here.
All right, ma'am, were you able to speak with an attorney in your case, Ms. Talley?
Yes, I was.
All right, are they representing you or just give you advice only?
Advice only.
Okay, then what I suspect is you probably want to be able to talk with Mr. Coleman directly.
Yes.
And Your Honor, I just have to vent my frustration that I've been sitting there for 2.5 hours and no one has told me that I could have talked to Ms. Talley by now. That's very frustrating. And I do have other things I need to do. And it's not on Ms. Talley. I will speak to Ms. Talley. We work something out, but that's just unfair to me to be here for 2.5 hours. And I could have spoke to her and could have had something worked out prior to this. But I'm just voicing my frustration, and I'll talk to Ms. Talley if you can put us in the breakout room.
All right. Before you go, Mr. Coleman, let me see if there's another person you need to talk to. Ms. Trinita Green.
Yes,
All right, ma'am, did you talk with an attorney?
I did.
All right, and did they agree to represent you? Just give you advice only.
Advice only.
All right, so that's actually 2 people, Mr. Coleman.
I can talk to Ms. Talley first, and then you set me up to give me controls, or I can talk to Ms. Talley first, and then I'll speak to Ms. Green next.
Okay, thank you.
Supposed to be advice only. You know, in the future, if I have my own room, I can work this stuff out way quicker than this.
All right. Please raise your right hand to be sworn in. Right. Yeah. Do you swear or affirm that the testimony you're about to give will be the truth?
And you can't do that. So with that being said, Ms. Burns, that's your second warning for taking the floor.
I appeal the ruling of the
Please
chair.
feel free.
Okay?
Please feel free.
You sound ridiculous.
Okay, appeal, there you go. Ms. Burns cannot illegally take the floor using requests for information that are not valid. That's the appeal. Go ahead, Ms. Burns. Ms. Burns.
Thank you. It is too much. Let me tell you something, Liddell. You are so rude. And it's just, you're terrible, Chair. Absolutely awful, Chair, that you are. And don't you ever feel free to comment on who somebody's grown, because your behavior is not depicting that right now. It's not. You are so out of control.
All right. I guess you just swallowed gum?
Yep.
Okay, that's a yes.
Yes, ma'am.
All right, why were you late today?
Oh, I got here around 9:30, just to be honest.
No, I'm asking why, because docket starts at 9.
Oh, traffic. It was really, I have a dually, so there was.
You had what?
I drive a dually.
Okay.
It was very, very hard. I went to like all the parking lots around here to fit. All of them were packed. I actually parked like 3 blocks down. So I finally found a spot.
Well, you have to put that in your schedule because it's not a traffic issue. Because there's no school. I can come from across town to downtown within 15 minutes because there's no traffic. All right, so today is your plea deadline date. Are you accepting the plea or rejecting it?
Certainly going to reject it.
All right, how long is this jury trial going to last?
I would expect 2 to 3 days, Your Honor.
All right.
And Your Honor, there's also a forensic interview. And so I'm going to ask you for an expert. He's appointed.
Just 1 second. I'm looking at this and it says that on May 1st, there was an offer tendered and your plea deadline date was May 16th. And then May 16th, your plea deadline date expired. So actually today we're here for a jury trial.
Okay.
So today is your jury trial. So we'll see you back here at 11:15.
Tomorrow morning?
No, today.
Oh, today. Okay.
All right. All right. Thank you.
Was there a victim in your case?
Well, if y'all consider it, well, yes, ma'am. Yes, ma'am. Was a victim in the case.
Who was the victim?
Well, I say the victim was the woman in my family. I really consider my family as being a victim because the things that I was doing, I really abandoned my family. So I really consider, as I took that class of victim awareness, I just really considered like me putting my family as the victim. That's how I did the program, because I really abandoned my family and I left to do those things.
So the person who was engaging in the sex act, you don't consider that person a victim?
No, ma'am. No, ma'am. I don't, because the other thing was already going on once I came about, and I'm pretty sure they might still be going on. So I just know the person who really took the loss out of everything, out of all the situation, was me and my family, and I consider them as being a victim for leaving.
That's actually one of the proposals that they have on the Access to Justice Committee. People just make their own court case. But the problem is, how am I supposed to make a landlord-tenant docket or criminal docket if everybody just picks their own? It doesn't make any much. Now I can do it. I can switch from landlord-tenant to criminal that fast. in a heartbeat. Okay. Sure, I do it on Tuesdays. I do both sides on Tuesdays. I think there's a lot of judges who wouldn't be able to handle such a thing. Yes. If my time.
Okay, so yeah, so their job is to collect money. But it would seem like to get this far behind, you haven't paid any money.
Yes, this has been over. This hasn't been since I moved to Georgia. This has been an ongoing dispute before I even moved to Georgia. It's just gotten into you guys' hands years ago.
Whoa. Okay. There's an arrears. So there's $1,074 you're supposed to pay a month. They're asking for an additional $50 a month and $3,222 purge due by April.
Can I get that extended out?
The state would object.
Extend it out for what? You got until April.
To pay the purge?
That's almost 6 months.
The reason I ask is because, like I've told them, I have a whole family. I'm married. So as a man, I do make the decision to take care of my family first with the little money that I do be having.
So is this just one child, Ms. Clark Davis? Or Ms. Walton?
Your Honor, I don't have that information in front of me. If the agent could look and let the court know, but I would say in furtherance of our objection, that Mr. Jones has not made a payment in now over 2 years. So certainly his current family, I guess he's referring to, have to be taken care of, but so do the children that he's a father to. So considering
right there too. If those people, if the children or child, are they not family that need to be taken care of, Mr. Jones?
I can give you a preliminary correct answer, and I can give you the truth. Yes,
I really just want a yes or a no. I don't care about political correctness. They're children too. You might not like their mama.
My kids in North Dakota is living very well, better than most people on this screen. So when I make a decision to take care of my family here in Georgia that is not living as well as my kids in North Dakota, I feel that's a judgment call in my best interest. Now,
well, I mean, if you dispute whether you did it, wouldn't you want to have an attorney to help you present your side of it?
But why am I even still dealing with this? If he first of all hasn't even showed up to press charges against me, and second of all, why the fuck? I already done time for it 4 times already.
So don't swear at me. Okay. So the problem is there's a trial date where he would have to be present and testify. And unfortunately, you keep not getting to the point of forcing him to show up or not show up because you have to show up for your trial. And when you don't show up for a trial, then it doesn't matter whether he showed up.
If you guys hear what I go through every fucking day.
You got to show up for things and to resolve them. And if you don't show up, then this is what happens.
It'd be easier if I had a fucking house.
Okay. You need to stop swearing at me.
This court is convinced of a couple of things. These parties were married in 1989 in Michigan. They lived here until they moved to Alaska in 2008, filed a tax return here in 2009, owned property in Michigan here until 2018. But the most telling thing to me about all of this is that she moved back here, the wife, in 2020. She didn't file for divorce until 2022. She lived here for 2 years. It's not like she lived here for 6 months and then quick filed. She lived here for 2 years, and he did nothing in Alaska to file. He did nothing to try to prevent her from filing here. And so she filed here. She lived here this whole time since 2020. Now it's 2023. And I mean, he had to suspect at some point she was going to file for divorce. you can take all of the other factors, you know, she was a stay-at-home mom here, she worked there, he didn't have a business here, but he has one there. I mean, all of those things, there's going to be people in both states. This isn't going to be convenient for anyone because they live in 2 different states, period. It doesn't matter what I did. It would probably be the most fair if I ordered you to go to Arizona and do it, because then everybody would have to fly. Well, maybe not the bed and breakfast people, may have to order like Texas or something, but it's not going to be convenient because you're all going to have people in both states. And I didn't look at the law about spousal support in Alaska or Florida or Michigan, because that's not what's before me. That is forum shopping. And I don't think either one of them filed in any state because they thought the law was better or worse. In my experience, people aren't looking at what the law says before they decide if they're filing for divorce when they're deciding to do that. I'm not convinced that the pleading this motion is timely in regard to the requirement under the case law. Again, it's frustrating to me that this is after a motion for summary disposition, after an answer, after discovery has not only started, we've been all in, and you guys have been working, and we've been here, I think, 3 times on motions to compel. We did the request for the confidentiality agreement. I know you guys worked a lot of time on that. In this court's opinion, it would be very inconvenient to just stop here and restart all of it in Florida because all of those expenses, every bit of ground that you've gained would now be lost. I am concerned that this is in fact games play, and I don't appreciate it. And it's not going to go well for people if I realize that that is in fact what is happening. To me, it looks like, okay, well, now we're just not going to turn it over because we really don't want it to be in Alaska. And if we just really keep being a pain, that judge over there is just going to say, fine, send it to Alaska. That's not happening. It's not going to happen. So you can either start turning it over or we'll face those consequences. I'm not just going to give it to Alaska because it's aggravating, because nobody's listening to my order. That is like the exact opposite of what I'm going to do. I don't believe you when you say he's making no money. I mean, we've got lots of people from Michigan living in Alaska doing exactly this work that would be employees of a firm such as his. So that's probably why they want to see the payroll, because if there's no money on paper, there's probably money going out as far as paying employees and or the owners. Again, those are issues for trial, though. That's not what today is about. Today is about convenience. And again, it is a balancing test. This forum is given deference unless the moving party can show otherwise. And I just don't think you can meet that burden. If you looked at, I do a lot by Zoom. I typically don't do trials anymore by Zoom because it is difficult. In this situation, the majority, if not all of the witnesses, I anticipate allowing to come by Zoom. Unless it is just so cumbersome to show them an exhibit and they have to be in the same room as us, I intend to utilize Zoom. The Supreme Court wants us to utilize Zoom as much as we can to make sure that justice is accessible to all of us. So I intend to use Zoom. Again, I think we're weighing all the factors. The court's going to deny the motion for forum inconvenience. I don't believe that the burden has been met. I think that, like I said, it's not going to be convenient for anyone, but the great weight of inconvenience to leave it here in Michigan, I don't find there is one, and so I'm going to deny that motion. I am going to compel the requirement to comply with discovery, which I've said 12 times now. This time I'm going to add a little weight to it. I'm going to reserve the attorney fees in regard to discovery, not only this motion to compel, but every motion to compel he's filed, and the attorney fees that he has in drafting that confidentiality agreement. I'm not awarding that today. I'm reserving it for trial. We'll bring it up and we'll address that issue at trial. However, he has until June 15th to comply with discovery. Every day after June 15th that he's not in compliance, he's going to get charged $100 for non-compliance. Maybe that will get him and his people moving. The fact is this: if there was an attorney who thought that these things were confidential, there are many things that that attorney could be filing, just as Mr. Carpenter indicated, in both the state of Alaska and the state of Michigan to try to keep these things confidential and protected. He or she has not done that. So that makes me very suspicious that this is gameplay, but I guess we'll find out because now they're gonna have every motive in the world to file a motion.
Thank you, Your Honor.
Read the court rules.
You're
If
applying
not,
different court rules. You're applying different rules to Attorney Cox. There's no proof of fouling. There's no proof of fouling. There's no notary. There's no proof of fouling. He hasn't done a lot of things, but y'all keep having side conversations and applying different rules.
Ma'am, we have.
I'm not a ma'am. I'm not a ma'am. That's part of the discrimination we're facing.
Plaintiff, we have.
You're applying different rules to Attorney Cox than you are to us. He has never filed a proof of fouling before this court. He has no evidence about anything he's done. It's just his word.
I'm not gonna continue this, but you should read the pleadings. He filed certificates.
Okay, anything else?
No, Your Honor, we understood, Your Honor. Thank you. Gracias, señorita.
Okay, you are all set. Thank you.
Madam.
All right, everybody, that's it.
Thank you. Have a good weekend.
Yeah, I will have a good weekend because I won't be here and then Paul will finally be back, so.
Sounds good.
Okay, see you, everybody.
Bye.
Thank you.